Well, thank you all for coming. I'm going to get started because we don't have nearly enough time to address this extremely important question about religious freedom and the Pledge of Allegiance. But we're really, really privileged to have such distinguished people joining us for a discussion of these issues. I'm Alan Wolfe. I'm the director of the Boisi Center, and I just want to begin by thanking my assistant Eric Owens here for helping put this together. So what I'll do is I'll introduce the speakers, and then each one will have some time to share with us their reflections, and we'll leave time at the end for discussion and comments. Michael Newdow is the person around whom essentially we organized ourselves. Mike is a lawyer, physician, and First Amendment activist whose legal challenge to the words "under God" in the Pledge of Allegiance reached the U.S. Supreme Court in 2004 in the case of Elk Grove versus Newdow. Newdow personally argued the case before the court, and although he lost 5-3 on grounds of standing, his performance was called spellbinding by the New York Times, virtuoso by National Public Radio, and the best oral argument of the entire Supreme Court term by the Daily Journal. The case has now been refiled with different plaintiffs, although I think you're still going to be a plaintiff, is it? And is likely to return to the Supreme Court in coming years. Mr. Newdow also practices emergency medicine in Sacramento, California, where he has also filed a legal challenge in federal courts to the national motto, "In God We Trust." He was an undergraduate at Brown, is an MD from UCLA, and his law degree from the University of Michigan. Wendy Kaminer is a widely respected and published lawyer and social critic who writes about law, liberty, feminism, religion, and popular culture. Her latest book is Free for All, Defending Liberty in America Today. A former Guggenheim Fellow, she's the author of 6 previous books, including Sleeping with Extraterrestrials, I feel like George W. Bush here, The Rise of Traditionalism and the Pearls of Piety, I'm Dysfunctional, You're Dysfunctional, The Recovery Movement, and Other Self-Help Fashions, and others. Her articles and books have appeared in numerous publications, including the New York Times, the Atlantic Monthly, and the Wall Street Journal. She's currently writing a book about ethics for Beacon Press. Phillip Muñoz is an assistant professor of political science at Tufts University, where he teaches political philosophy and American constitutional law. He's currently completing a book on religious freedom and the American founders, from which he has published recent scholarly articles on James Madison and George Washington and their views concerning religious liberty. His work has appeared in the American Political Science Review, the Review of Politics, First Things, and the Wall Street Journal. In 2004, he testified before the U.S. Senate Judiciary Committee on the question of religion in the public square. He's also a BC alum, having gotten his Master's of Arts degree in political science, in the department of which I'm now a member, and he has his PhD in political science from the Claremont Graduate School. So let's begin with Mike Newdow, and thank you all very much.
Thank you for having me. We're here to discuss basically the case, the Pledge of Allegiance case, and more broadly, the questions of the religion clauses of the United States Constitution. And to me, what this really is not even about religion, but it's about equality. The question is, do we want a government that respects all religious views equally? I think it's clear that we do. That's what the framers wanted. And the issue is whether or not government is respecting all religious views equally when it says we are a nation under God. I think it's pretty clear that it's not. I don't believe in God. Other people do believe in God. And the government has taken the position of the other people. Justice Antonin Scalia says the government may not lend its power to one or the other side in controversies over religious dogma. And I can't think of a greater controversy over religious dogma than whether or not God exists. And clearly, the government has taken the position that God does exist when it says we are a nation under God. Or in my other challenge, whether or not it says that in God we trust. I think if we take the words for what they say, in God we trust, I think it's hard to suggest that that doesn't endorse the idea that there's a God and that we trust in that God. And there are Americans who don't, and they should be respected equally. So I want you to keep that in mind as you go here, listen to what's being said today, whether or not government is treating people equally when it takes one side or the other. I think, again, it's clearly not. And what I think you're going to hear on the other side is basically excuses as to why we can forget that ideal, why it's okay to trample on that ideal, as we've done many times in our history and are doing today. And it has real effects, too. This isn't just an academic exercise. Atheists are despised by a number of people in this country. Studies continually show that atheists, a third of the population doesn't like an atheist just because that person's an atheist. Half of the population won't vote for an atheist, even if they agree with everything that person stands for. And I think that the reason we have those views is to a large extent because the government reinforces that view. Government keeps telling people, real Americans believe in God. We'll tolerate those people because we have something in the Constitution, but we know that the real people they believe in God, and those people are kind of guests in our country. And I think that's wrong. I think this is just as much an atheist country as it is a Christian country or a monotheistic country. It's a country for all people, and that's what the framers had in mind. Now people say, well, but the framers were all, they all believed in God. That's true. That's probably true. I'm not sure that's true. But even if we assume it's true, the framers also were all white. They were also all men. The Constitution was made to protect everybody, and especially in terms of religion. If you look around at what there is in the Constitution, in the Bill of Rights, there's nothing about race in the Bill of Rights. There's nothing about gender in the Bill of Rights. There is something about religion. It is the first freedom, the first thing that's discussed. And the framers said, Congress shall make no law even respecting an establishment of religion. It doesn't have to establish it. It has to be anything that it respects an establishment of religion. Congress can't engage in that, or prohibiting the free exercise thereof. And so we have two clauses, one that's called the Establishment Clause, the other is the Free Exercise Clause. And both of them generally work together. Sometimes there's tension between them, but in some cases there's no tension whatsoever. For instance, under God and the Pledge of Allegiance, or in God we trust on the coins and currency. There is no one's infringing on anyone's free exercise rights. You'll hear people say, well, you're not letting us go to the public square and talk about God or whatever. That's totally bogus. You individuals throughout America can go to the public square at any time. The public square is the public's square. It's not the government. The government is very different, and the government is forbidden from entering the public square in controversies over religion, and that's what the whole thing's about. So try and keep those separate as you go through this, and not get confused by, people start talking about free exercise issues. Free exercise applies to private individuals. Establishment Clause issues applies to the government. The Supreme Court has spoken on this. It said there's a crucial difference between government speech endorsing religion, which the Establishment Clause prohibits, and private speech endorsing religion, which the Free Speech and Free Exercise Clauses protect. So if we keep those separate, I think we'll understand what this is about. So what are the reasons? It seems pretty clear. All right, the government's taking one side in religion. It's not allowed to do that. What are the reasons against this? Why would people be against it? You'll ask yourselves that tonight. And Phil, I know he's taking the opposite side. I don't know if he actually believes it, but for that argument, right, we have to ask ourselves, why would anybody be fighting what I'm fighting for? Why would anyone be against that? No one is taking away anyone's rights at all. There is no right to use the government to propose and expound upon your particular religious view. That's what's forbidden. And the framers knew that that's a dangerous thing. It had seen it throughout history. It knew about the Crusades and the 30 Years' War and the Inquisition and all those things. They didn't know about what's going on in Iraq now, or Sudan, or Northern Ireland, or Israel, or Indonesia, or all over the globe where we continue to have religious battles. But they knew that when people have an opportunity to get the government to do their religious bidding, it ends up with conflict. And it's a very important idea, right? You have to keep that in mind. What they had, the original thought was that we don't want turmoil in our society, and the way to avoid that turmoil in terms of religion is for government to say this is the established religious view, and therefore everyone will believe the same thing, and we won't have people fighting. And our framers realized that that is totally backward. That the way to get people not to fight is just to simply have the government respect them all equally. And once you do that, you don't have the battles. That was a brilliant idea that they came up with. We accept that now because we pretty much have that in this country, except against atheists for the most part. But if we realize the beauty of that, they're just granting equal respect, then we'll realize why we shouldn't have things like under God and the Pledge, etc. I think it's just some of the arguments that I think you'll probably hear. One of them, like they always talk about the Declaration of Independence. That's what comes up. I'll just mention that when you go to the Supreme Court or any court, they don't rule whether or not it's undeclarational. They rule about whether or not it's unconstitutional. Right? So this argument, well, look at the Declaration of Independence. Declaration of Independence is not a document that gives us our laws. It's the Constitution that gives us our laws. And we ought to be thinking about what the Constitution says. And the Constitution is very clear. It doesn't want religion in there. And if you look at what everybody said back there, all of the framers, everyone, there is not a single quote from anyone who ever said, we don't want this Constitution as it stands, that this Constitution is not supposed to protect all Americans. Nobody ever said that that's how they read this Constitution, any of the framers. There were some who wanted it to protect only people who believed in God. Luther Martin, for instance, was Attorney General of Maryland for 30-something years. Okay? He said, what's the matter with this Constitution? We don't talk about God in there. We don't have some allusion to a state of future rewards and punishments. That's right, we don't. And he lost out on that. Benjamin Rush, after the Constitution came out, remember in 1787 they proposed, they had a convention to come up with this new document. 1789 it was put into effect. 1788 it was ratified. Right? And then when the first Congress met, they got together and they said, all right, in addition to this Constitution, we need a Bill of Rights for further protections against the encroachment by government. And so they put in the federal government. So they put in a Bill of Rights. Well, as that Bill of Rights was being proposed, James Madison proposed it June 8, 1789. A week later, Benjamin Rush writes a letter to John Adams, who was vice president of the country. As such, he was the president of the Senate. And he said, many pious people wish that the name of the Supreme Being had been mentioned somewhere in the new Constitution. Perhaps an allusion can be made to his goodness and his providence in the proposed amendments. No, you can't get that. We didn't want that. And you can look at the quotes of all the individuals who spoke on this subject. James Iredell, who was one of the first Supreme Court justices, said if any future Congress should pass an act concerning the religion of the country, it's an act that they are not authorized to pass under the Constitution. Richard Dobbs Speight, also from North Carolina, became the governor. He said, as to the subject of religion, no power is given to the general government to interfere with it at all. Any act of Congress on this subject would be a usurpation. Now, this is just referring to the Constitution. This is before we get an establishment clause that says no law respecting an establishment of religion. This is before, and this is just from the body of the Constitution. And you say, well, who's Richard Dobbs Speight? Who's James Iredell? Never heard of those guys. How about Alexander Hamilton? You've probably heard of him. He's on the $10 bill. He talks about the difference between the King of England and the President of the United States. The King of England, he says, is the head of the church, the National Church of England. He says the President has no particle of spiritual jurisdiction. Nothing. And if you don't like those guys, then go to the father of the Constitution, James Madison, the guy, I think, who put this together more than anyone else, who was more responsible for our freedoms, who said there is not a shadow of right in the general government to intermeddle with religion. Its least interference with it would be a most flagrant usurpation. I mean, those are words, I think, how much clearer can you be? If you wanted to say, we don't want government to have anything to do with religion, what other words could you do except there's not a shadow of right. There's no particle of spiritual jurisdiction. I think it's pretty clear. Back to the Declaration of Independence, since they will talk about that oftentimes. Let's think about what it says. The Declaration of Independence, it says we're going to declare our independence. We don't like what King George III is doing. And we have these truths. Remember, we hold these truths to be self-evident. There's 5 truths. First one is that all men are created equal. Hey, great idea. That's what our nation, I think, is founded on. Then they come up with another one. They are endowed by their Creator with certain unalienable rights. Well, if you think about that right away, there's a tension between those two things. You can't say all men are created equal and that they are endowed by their Creator when you realize that some people don't think there is a Creator. That's not treating them equal in terms of their religious views. So there's a tension, and you're going to have to see which one did the framers want to be above the other when we got to the Constitution. Then they talk about some of the other truths. The third one is that among these rights are life, liberty, and the pursuit of happiness. He said that to secure these rights, governments are instituted among men, deriving their just powers not from God, as in many other countries, but from the consent of the governed. And the last truth, the one that I think is more important than any, says that what's going to happen? He says, whenever any form of government becomes destructive of these ends, where we get these rights, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles, and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. And I think that's the key. They were saying in the Declaration of Independence, we're going to come up with a government. We don't know what it looks like now in 1776, but we're going to come up with a government to affect our safety and happiness. And we'll see, which one is it that they wanted? Did they want this nation of equality, or did they want this nation under God? Well, I think you can go through and see which it is that they came up with. First of all, those quotes that I just mentioned. You can also go through and you can look at the progression. In 1779, 3 years after the Declaration of Independence, back in Virginia, which was really the hotbed of religious freedom, Thomas Jefferson, he's feeling hot. He just got the Declaration of Independence through. Everybody's going, oh, TJ, you're the man. He says, what else can I come up with? He says, I got it. I'm going to come up with a bill for religious freedom. And in 1779, when he's very popular, right, he's the guy who did the Declaration of Independence. He's just about to be elected governor of Virginia. He tries to get past his bill for religious freedom. Can't get it passed. Okay? Then he goes off. He becomes ambassador to France. He's gone for a while. And Madison comes up and takes up the gauntlet. Madison in 1784, right, this is still before the Constitution. The convention doesn't assemble until 1787. So 3 years before that, Madison's down in Virginia. And Patrick Henry, who we all know, give me liberty or give me death, Patrick Henry comes up with this idea that he's going to have a bill to establish a provision for teachers of the Christian religion. He says because Christianity, spreading Christianity is a great thing. It corrects the morals of men. It restrains their vices. It preserves the peace in society. He says this is a good idea. We should have and it was actually a very progressive bill. He was going to fund teachers of Christianity, all sects of Christianity. Remember, there was the Anglican Church in Virginia, right? They had an established church. He says, no, that's not good. We should take all Christians out there and support all Christian sects. Madison looks at this and he says, well, this is a bad idea. He says, Pat, you don't have it right. We want this universal appreciation, this universal respect. He says, not just for Christians. He says, who does not see that the same authority which can establish Christianity in exclusion of all other religions may establish with the same ease any particular sect of Christians in exclusion of all other sects? He says, bad idea. We want this bigger. So he says to the legislature, the House of Burgesses, he says, wait a second, before we vote on this bill, right, give me a year and let me give you reasons why I think it's a bad idea. And on Christmas Eve, 1784, he gets a vote, 45-38, he wins. And so they say, okay, well, wait a year. Madison, go out and tell us why this is a bad idea. And he does. And he writes his very famous memorial and remonstrance. I suggest everybody reads it. It's 5 pages long. It's incredible. It applies today just as much as it applied back then. It's a wonderful document. And you read it. You read what he talks about. And if you look through it, what you see, what struck me at least, is 14 times he talks about equality. Right? This is a bill about religion. He says, equality, that's what it's about. Why is Patrick Henry's bill no good? Because it violates the equality, which ought to be the basis of every law. Because we cannot deny an equal freedom to those whose minds have not yet yielded to the evidence which has convinced us. And the one that I think is most appropriate in terms of what we're talking about today is it degrades from the equal rank of citizens all those whose opinions and religion do not bend to those of the legislative authority. That's what it was about. He realized that once government takes one side, once we start helping one religious group, however broad that group is, as long as we're excluding other people, it degrades from the equal rank of citizens, those people. That's why I think we have 33% of the population that won't vote, doesn't like atheists to begin with, or half the population that won't vote for it, because the government keeps using its power to tell people that's the correct view to have. I think that's a bad idea. And so I think would have Madison. So anyhow, 1785, he comes up with his memorial remonstrance. Patrick Henry's bill is defeated. And 1786, he revives Thomas Jefferson's Bill for Religious Freedom, and he gets it passed in the Virginia legislature. So we see there was a big change between the time of the Declaration of Independence, because in 1779, 3 years later, they couldn't get that bill passed, and then in 1786, they did get that bill passed. Right? People started to realize this idea of being equal, of treating all people alike. We can see that in the Constitution itself. When the Constitutional Convention came out, we can look through the document. First of all, we notice the preamble. We, the people of the United States. Nothing about God. There were mentions of God all over the place. I mean, today, in the state constitutions, if you look, all 50 talk about God. Our federal constitution doesn't. We didn't want that in there. Right? You can look at the only oath of office in the Constitution, Article 2, the oath for the President. I do solemnly swear that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution, period. There's no so help me God. There's so help me Gods all over the colonies, not in our Constitution. And then you can look at Article 6. Article 6 talks about that we have this Constitution, it shall be the supreme law of the land. And it says that everybody, every official, every legislative branch official, every executive branch official, every judicial branch official, be they federal or state, has to take an oath to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. That was an astounding thing to write. There were 11 state constitutions in effect at the time. 9 of them had religious test oath clauses, and the other 2 didn't say you couldn't have one, they just didn't have it. So to come up with this idea that no religious test shall ever be required was extraordinary. Now, what's really extraordinary to me in terms of whether or not, people say, well, the framers would have wanted God in our government and in our pledge and in our motto. The very first act of the government of the United States. Right? Remember, they met at the convention in 1787, they ratified it 1788, 1789, the first Congress met, our nation began, and the very first act they had, statute number 1, was that oath that they said they had to take. They said, okay, we need an oath. So they sent it out to committee, and the committee came back and said, here's the oath we suggest that you should have. I, a representative of the United States in the Congress thereof, do solemnly swear in the presence of Almighty God that I will support the Constitution of the United States, so help me God. 2 references to God. Right? Then goes before the whole Congress. Congress looks at, we don't know what the debates were, there's no recording of the debates, but we do know they were doing it pursuant to Article 6, the one that says no religious test shall ever be required as a qualification to any office or public trust under the United States. And they take out both references to God. The first act of the United States of America is removal of the two references to God of the oath of office for Congress itself. I do solemnly swear that I will support the Constitution of the United States, period. That's it. There's no God stuff. Now, why would they take it out of their own oath of office if they wanted God to be in our government? If they wanted this thing? Why would all of them, every single person who spoke on the issue say, we don't want God in here, we don't want religion, the government has no power to legislate or to have anything to do with taking opinions on this matter? Didn't Justice Scalia get it right when he said the government may not lend its power to one or the other side in controversies over religious dogma? Again, it's a question of equality. I hope you understand that. It's not a question of belief in God versus disbelief in God. It's a question of whether or not you believe in equality or you don't want to believe in equality. I hope you choose the latter. Thanks.
Either place, whatever you like.
Well, just like a lawyer, I have argued both sides of this case. Isn't that what people can't stand about lawyers? When I've spoken to secularist groups, I have sharply criticized Michael for bringing this case because as a secularist who's very concerned with religious freedom, I think that as a practical matter, it's more likely to retard rather than advance the cause of secularism. Yet at the same time, I helped draft and edit a friend of the court letter supporting Michael Newdow's case. I did that just a few months ago because it was submitted by a secularist organization that I advise, and because I think that in theory, I think that in principle, the presence of under God in the pledge does represent a gratuitous imposition on freedom of conscience. It's just that as a practical matter, I think, and Michael might consider this making an excuse, I think that it's a relatively minor one. And as a non-theist, as a secularist, I tend to regard the presence of under God in the pledge or in God we trust on dollar bills as minor facts of American life. And I'm not sure we have much choice. I don't think it's hard to tolerate them, and I don't think we have much choice but to tolerate them. Now, Michael gave you what I think is a very good and valuable civics lesson. And I share a lot of the sentiments and a lot of the arguments that he's made. But a civics lesson isn't just about principle and constitutional theory, which is not to say that they're not very important. I think a civics lesson is also about politics. And I want to talk about some of the pragmatic and political considerations that I think should be involved when you consider bringing a challenge like this. First, I think the pragmatic arguments, I think they're fairly obvious. From my perspective, of somebody who cares about freedom from religion, this is a case that we can't afford to win. If Michael Newdow wins this challenge, we will have, and I don't think that's likely, we will have a Supreme Court decision that affirms the power of government to put under God in the pledge. And I think for all of the reasons that he has eloquently stated, that would be a very bad thing. On the other hand, if by some stray chance, and maybe if there really is no God, and he does win this argument, we will end up with a constitutional amendment increasing the power of government to inject religion into public life faster than Joe Lieberman can say amen. That would be a very serious restriction on freedom from religion. Now, advocates of public religiosity, of government-sponsored religion, like to say that the First Amendment guarantees freedom of, freedom not freedom from religion. And I think that is quite wrong. Your freedom from my religion, my freedom from your religion is precisely what the First Amendment protects. And that's why we have an establishment clause in the First Amendment. The prohibition on government establishing religion is to make sure that you're free to make your own religious and spiritual choices, and that you also have the right not to be forced to support financially or otherwise somebody else's spiritual and religious choices. Now that freedom, the freedom that's promised by the Establishment Clause, has been seriously eroded recently, and not by the presence of under God in the pledge. I don't know how many of you saw what I think is a very important series that was in the New York Times and the Boston Globe a couple of weeks ago about the enormous number of privileges and exemptions that are enjoyed by religion today. I think the Times reported that there were just hundreds and hundreds of privileges and exemptions in areas ranging from tax law, employment law, land use regulations, to things like regulations on daycare centers. It's unprecedented, and I think it's fair to say, as one law professor quoted in the New York Times said, that there really is no longer separation of church and state in this country. And again, it's not because we mention God on our dollar bills. Now, I realize that government funding of sectarian religious activities is not the subject of this panel. I bring it up because it is the primary reason with my impatience for Michael Newdow's challenge. It's the extent to which government now supports religious activities is again a really serious threat to religious freedom. It is the face of theocracy. Now, it's a rather benign face of theocracy. It looks like a benign face of theocracy to many people, but think about what it does. It creates a two-tier system for people who are employed by secular organizations and people who are employed by religious organizations, even if they're not engaged in religious activities. It involves the government in proselytizing, in financing religious proselytizing, and it raises serious questions about government favoritism of religion. As both the Times and the Globe noted, most of the federal money that's going to religious groups is going to Christian groups. Now, I understand that a lot of non-theists view the presence of under God in the pledge as a form of proselytizing. But how does it compare to federally sponsored missionary work here and abroad on the scale which it's happening today? And I'm about to use a metaphor that is probably a little bit dangerous since Michael is an emergency room doctor, but as I was thinking about this, I thought to myself, if secularism is the patient, this is like being an emergency room doc and taking care of a patient's broken finger while he has a heart attack. Now, I'm afraid that Michael's going to tell me why it's sometimes okay to do that if you're an emergency room doctor, and who knows, maybe it is, but that's what it looks like to me. So, I look at this case and I see that Michael Newdow is going to have, at best, a Pyrrhic victory. And because of that, as somebody who's really deeply concerned about religious freedom, I'm willing to accept a few under gods here and there. I can accept it in the pledge. I can accept a mention of God on our currency because I consider it a small price to pay to keep all members of Congress off the steps of the Capitol, pledging allegiance to God and making the bizarre argument that religion is somehow under siege in this country. And Michael talked a little bit about the need to ward off turmoil and the ways in which our guarantees of freedom of and from religion help save us from religious wars, religious turmoil. I think that's very important. And I have the sense, I may be wrong, but I have the sense that by accepting just a bit of what Justice Brennan called ceremonial deism, we might actually ward off some religious turmoil. And by ceremonial deism, Justice Brennan was talking about under God in the pledge, references to God on the dollar bill. He said what distinguished them was their meaninglessness, that by constant repetition, they no longer have any content. I mean, I actually think that ceremonial deism should be much more of a concern to religious people. I think it's rather demeaning of a lot of people's religious beliefs than it is to me as somebody who's not religious, somebody who's a non-theist. In any case, we will not eradicate ceremonial deism in this country, and I think it is counterproductive to try. I think that even many people who feel very strongly about separation of church and state are not going to get behind an effort to eliminate under God from the pledge, to eliminate references to God on a dollar bill, because for most people, God on a dollar bill is about as much like a prayer as the uses to which dollar bills are put. Now, I understand that pragmatic concerns, like the concerns that I'm raising, should not always be paramount. I don't mean for a moment to diminish the very important principles about religious freedom that Michael's talked about, and I admire him for the passion and the conviction that he's given to this cause, and I admire him greatly for doing this, because I'm sure that he gets a lot of hate mail, to say the least. It takes a lot of strength and a lot of courage to put yourself out there and to bring the kind of challenge that he's brought, even though I wish he hadn't done it. I do think that when you enter the political sphere, you have an obligation to consider the pragmatic consequences of your actions as much as you consider the importance of the principle. I think you have an obligation, a responsibility, a civic responsibility, to balance the importance of the principle with the likely consequences. And this is one case where I think the principle of eliminating under God in the pledge is actually a lot less important than the cost of trying to eradicate it. Now, what really is the principle that's at issue here? It's very important to remember that in the 1940s, the Supreme Court established the right not to say the pledge in an extremely important and very eloquent opinion, Barnett versus West Virginia, and that involved a challenge brought by Jehovah's Witnesses to compulsory recitation of the pledge, and they brought the challenge on religious grounds. I recommend that opinion to you because I think it's one of the most eloquent defenses of freedom of conscience that you may read, certainly in the annals of constitutional law. So the right not to say the pledge has been established by the court. That's not what's at issue here. The right not to say, you also have a right not to say under God when you say the pledge. That's not at issue here, though I think it's fair to say that that might be that's a right that it might not occur to a child to exercise. You could say that the right that's involved in this case is the right not to hear other children say under God in the pledge. But I think that's not a fair way to characterize it, considering the government's role in inserting under God in the pledge and considering the susceptibility of children to peer pressure. So, put most sympathetically, and I think this is a fair way to put it, I would say that the right that's involved in this case is the right to prevent the government from engaging in a soft form of indoctrination of school children. Now that is a very important right, but this is, in my view, a very trivial form of indoctrination. Now, I have a lot of sympathy personally with children who don't want to say the pledge, with parents who don't want their children saying the pledge. When I was in elementary school, I said the New York State school prayer every morning straight through, followed by the pledge, and I always hated it. And when I got to the 7th grade, thanks to the Supreme Court, I no longer had to say the prayer because the court had declared it unconstitutional. And I remember feeling quite liberated by that. I always found that prayer very alienating. I always thought it was a Christian prayer simply because it wasn't the kind of prayer that I heard on my occasional forays into temple. So one morning in the 7th grade, I decided that I wasn't going to say the pledge either. It occurred to me, having been liberated by the court from saying the prayer, it occurred to me that maybe I just shouldn't say the pledge. So maybe all those things that people tell you about the dangers of eliminating the prayer are true. It got me to stop saying the pledge. Now, I didn't really care about the presence of under God in the pledge. I barely noticed it. I just didn't like the idea of compulsory group recitation. My homeroom teacher didn't know and probably couldn't have cared that the pledge was voluntary, and so he sent me to the principal's office. But the principal reached a compromise with my mother. I was allowed to stand and not put my hand over my heart and not say anything, and I haven't said the pledge since. So I am not unsympathetic, either in principle or personally, to the challenge that's being brought here. But I do think that both parents and children in these cases have a remedy. I think that parents can encourage their children not to say the pledge, and if that is asking too much of them, as it may be, because they may feel stigmatized, they may feel ostracized by not saying it, they can encourage their children to say the pledge and just omit unobtrusively the words under God. That's a real choice. You can stand up assertively for your beliefs and risk being demonized and stigmatized for them, as I suspect Michael Newdow has been, or you can stand up for your beliefs rather quietly. Those are real choices that most of us are going to have to exercise in life, and I think in some ways it's not a bad thing for children to learn how to exercise them early. Those are real choices for free people in a relatively imperfect world. Thank you.
Good evening. It's a real pleasure for me to be here. I've long admired Dr. Wolfe and the Boisi Center, and it's just great to be back here at Boston College. As Dr. Wolfe mentioned, I'm a BC graduate, so it's always fun to come home. I find myself in the somewhat awkward, possibly advantageous position of my opponents conceding that God's on my side. Rarely is one so lucky. I just hope I don't lose because of it. I had the pleasure of being in the Supreme Court when Mr. Newdow argued his case in 2004. And I'll say what others said, what Alan said in his introduction. Mr. Newdow did a fantastic job, just as he did tonight. I'll go even further, and I'm not just saying this here, I've written this in print. I believe that under all three of the Supreme Court's leading precedents, Mr. Newdow should have won his case. The inclusion of under God in 1954 was meant to be an endorsement of religion, and therefore clearly violates the spirit of Justice O'Connor's endorsement test. In the 1992 case Lee versus Weissman, Justice Kennedy ruled that a public school cannot include a prayer in a graduation ceremony because it, according to Justice Kennedy, it psychologically coerces students to pray. So if hearing one non-denominational prayer at the end of the school year is unconstitutional, surely a daily participatory recital with religious language in the classroom is. And given how the court has interpreted the Lemon Test, which requires legislation to have a secular purpose, clearly under God fails to meet the Lemon Test. So a fair reading of the Supreme Court's precedents, the endorsement test, the psychological coercion test, and the Lemon Test all lead to the conclusion that the Ninth Circuit was actually right in 2002, and that Mr. Newdow should have won his case, and that he lost at the Supreme Court not because he lacked sufficient legal arguments, but because the court's most liberal members were unwilling to push their arguments to their logical conclusions. The very fact that Mr. Newdow should have won is troubling, and it reveals how hostile the Supreme Court precedents are towards religion and how badly the Supreme Court has misconstrued the First Amendment's protection of religious freedom. Mr. Newdow did something that no one else probably could have done. He's shown us in a very public way the need to go back to the drawing board and for the court to rethink its precedents. If the court were to properly interpret the Establishment Clause, it needs to better understand the type of harm the First Amendment was meant to prevent. So what I want to do is take a step back, try to suggest a new approach, a more historically accurate approach to the First Amendment and the religion questions that come up under it. I'm going to try to do, the time is limited, but I want to try to do three things. First, discuss those larger purposes of the First Amendment, try to explain what constitutes a religious establishment, and then thirdly, let me try to clarify why I think Mr. Newdow's understanding of non-establishment is untenable. As has been said, the First Amendment aims to protect religious freedom, and it does this in two general ways. The Free Exercise Clause prohibits government from making laws that directly prohibit or regulate specific religious practices or actions or beliefs. The Establishment Clause prohibits government from establishing a religion. It's important to note that both clauses are meant to protect religious freedom. The reason why government is prohibited from establishing a religion is because religious establishments tend to abridge religious liberty. In other words, non-establishment is a means to secure the end of religious freedom. We're mistaken if we believe that non-establishment, or more generally the separation of church and state, is an end or principle in itself. Non-establishment is a means to protect the end of religious freedom. So if we want to understand the harm the Establishment Clause is meant to prevent, we have to ask, how do religious establishments abridge religious freedom? And to answer that question, we have to know something about religious establishments. What are they? Well, at the time of the founding, about half the states had some form of official religious establishment. Massachusetts, for example, didn't end its official religious establishment until the 1830s. So we can know what an established religion is, and therefore what the First Amendment was meant to prohibit, by examining the state establishments that existed at the time of the First Amendment was drafted. Each state was different. This is not a simple matter. But the states with religious establishments did the following types of things. They limited civil rights to members only of the established church. Most typically, this was done through religious tests for office, as Mr. Newdow explained. Under the 1780 Massachusetts Constitution, for example, you had to be a Christian to be eligible to be governor or lieutenant governor. As was mentioned, 9 of the 11 states that rewrote constitutions, Connecticut and Rhode Island did not rewrite new constitutions, but 9 of the states that rewrote their constitutions between 1776 and 1784 imposed some form of religious test for office. The framers meant to end that type of test. States with official establishments employed religious clergy. Like a college professor at a state university today, religious ministers were state employees, paid by the state. In a traditional establishment, the government also earned church property, just like the government owns the campus of a public university. States with established religions licensed and regulated clergy, especially clergy of dissenting religions. So if you were a dissenting minister in Virginia, for example, when they had an Anglican establishment, you had to get a license to preach. And that license told you when and where and under what conditions you could preach. Only members of the established church, moreover, could perform certain functions. Again, in Virginia, only officially recognized ministers could perform legal marriages. If you were a Baptist or a Presbyterian minister, you couldn't perform a marriage in Virginia under the Anglican establishment. So then we have to draw from those examples, what did the framers mean to prohibit? When the framers of the First Amendment prohibited laws respecting an establishment, they meant to end practices like limiting civil rights only to religious believers or to members of the established church. They intended to prohibit states from employing clergy as official state employees or allowing the state to own or control church property. They sought to prohibit the state or state employees from regulating who could perform religious services or regulating what religious ministers could preach. It's not sufficient to know only what the framers meant to prohibit directly in 1789. We have to extrapolate from their principles to our times. So if we were to apply these principles to today in the context of public schooling, what would a ban of religious establishments mean? It would mean you cannot have religious tests for public school employment or enrollment. The state of Massachusetts cannot say you must be a Christian to be a public school teacher. The state cannot hire official religious chaplains or ministers for public schools. The state can't directly fund religious schools because they are religious. The state can't say, we will fund Christian schools because we want to promote directly Christianity. Specifically with regard to the Pledge of Allegiance, the First Amendment should prohibit a public school from disciplining a student who would not say the words "under God," or any part of the pledge for that matter. A student may not be prohibited from attending school. A student may not be expelled from school or punished with the deprivation of a privilege. I don't know, you can't say you can't go to recess if you don't say "under God." You can't get lower grades if you don't say "under God." That's the type of thing the First Amendment was meant to prohibit. But to say that a public school may not force an unwilling student to say "under God" is very different from prohibiting willing students from saying the pledge. The framers never dreamed that the First Amendment's protection of religious freedom would prevent willing citizens from voluntarily expressing religious beliefs in a public place, including a public school. This brings me to my final point. Mr. Newdow's interpretation of the Establishment Clause is simply untenable. He would transform the right to religious liberty into a right to be free from the presence of religion in the public square. His understanding of religious freedom is as simple as this: I don't believe in God, therefore in public, you should not be allowed to express your belief in him. Let's not forget two things. First, the First Amendment is to protect religious freedom, not to limit it. Secondly, no individual is required to say the pledge, and no individual is required to say "under God." Mr. Newdow's legal argument is that he has the right to ensure that his child does not hear other children say "under God." Imagine if we applied this reasoning to the other parts of the First Amendment. Take the freedom of speech. If we apply Mr. Newdow's approach, The right to free speech becomes the right to silence others from speaking if they offend you. The right to freedom of association becomes the right to attend a school with only those whom you agree. Mr. Newdow fundamentally misunderstands what it means to possess a right. The right to association means that you can choose to associate or not to associate. The right to freedom of speech means you can choose to speak or not to speak. The right to religious freedom means you can choose to exercise or not to exercise a religion. You can choose to say under God or not. But your right to religious freedom does not dictate how someone else may exercise their right to religious freedom. So just as my right to free speech does not limit Mr. Newdow's right to say whatever he wants, a proper understanding of Mr. Newdow's right to religious freedom does not prohibit school children, if they so choose, to pledge allegiance to our flag and to the republic, one nation under God. I know that Mr. Newdow understands himself to be a crusader for freedom. I think his story is a great one, an individual taking on a whole establishment of sorts and getting all the way to the Supreme Court and almost winning. But in attempting to silence others from expressing their religious beliefs, Mr. Newdow does not articulate the argument for religious freedom. He has, in fact, embraced a certain type of religious fundamentalism. He argues for a creed that proclaims the government must prevent religious expressions that atheists find offensive. In short, he advocates for a modern atheistic form of blasphemy laws. It's a dangerous argument. That's not religious freedom. It's not what the founders meant to constitutionalize in the First Amendment, and it certainly should not be what the Supreme Court enforces through the Establishment Clause. Thank you.
I think we should allow you to respond.
Rebuttals? Oh, okay.
If you want.
Well, first of all, I guess we'll probably discuss this more tomorrow. I was invited to join Professor Muñoz's class in Tufts. But I guess he missed the point, where I think I said it, that there's a crucial difference between government speech endorsing religion and private speech endorsing religion. He keeps saying, you are not allowed to worship and you can't say under God, etc. You can say under God as you want. You want to get into the Pledge of Allegiance and get on your knees and take a cross and make the sign and Hail Mary or face Mecca. You can do that all you want. What you can't do is use the machinery of the state to do your bidding. And to characterize this as my trying to interfere with anyone else's exercise of their rights is ridiculous. If you have any problem, if anyone ever stops you, if the government interferes with your ability to exercise your free exercise rights, call me. I'll represent you free of charge, okay? I'm on your side. I want you all to have your right to worship your God as you see fit. But you don't have a right to use the government to do that. He talks about the public square. No one's interfering with the public square. If you and your buddies want to go out and have a revival meeting, you have every right to do that in the public square. You don't have the right to get the government to do it for you. That's all it is. It's a really simple idea. I don't know why there's a difficulty there. As far as Ms. Kaminer, all I can say is, Professor Kaminer, I guess.
You can call me Wendy.
Okay. As far as Wendy, this is the argument. I'm sure there were lots of blacks who didn't mind riding on the back of the bus. Hey, it doesn't bother me. I don't want to be with those white people anyhow. I like being in the back here. I get home just as quickly. There's no problem with that. But the issue isn't whether or not Wendy Kaminer is offended by this. The issue is whether or not it violates the Constitution. And there are people who are offended with this. And although she doesn't see the harm from it and says, well, it's trivial, no big deal, I see a huge harm from it. If you look at the polls that have been done, right, atheists are a despised minority. Why? In 1958, Gallup did a poll, said, all right, suppose there were a candidate for president. And they spoke of him because at that time there was governmental preference for males. They said, would you vote for him if he were and you agreed with everything he stood for, would you vote for him if he were a fill in the blank? Right? If he were a black, I think the numbers, I'm not sure I have them exact, but I think 64% of the population said no, I wouldn't vote for him if he was a woman. I wouldn't vote for him if he was a black, if he was a black for 53%. If he was a Jew, 28% wouldn't vote for him. If he was a Catholic, 22% wouldn't vote for him. Baptist was okay, 4% or something like that. Atheists, 75% wouldn't vote for him. Now let's look at what's happened, the results of that polls since 1958, and the last time they did it, which was 1999, last time I'm aware of at least. Okay? In 1999, they said, all right, would you vote for a woman? Went from 64% down to 7%. Jew went from 28% down to 6%. Black went from 53% down to 4%. Atheist went to 75% to 49%. Still half the population wouldn't vote for a Jew. Right? More than 10 times almost every other group. How come? Because the government didn't stop sending them a message that atheists are second-class citizens. They did it for blacks, they did it for women, they did it for Jews, they did it for Catholics, they didn't do it for atheists, and we still have the effects of that. The fact that I can't get elected to public office, despite the fact that I'm amazingly charismatic, right, is extraordinary, and the reason is because the government keeps sending that message. So although Wendy Kaminer doesn't see it, I see it. And the idea that, well, this is okay. James Madison said it, He said, it is proper to take alarm at the first experiment on our liberties. It is the first duty among citizens, not to sit there and say, hey, it's okay. As far as Justice Brennan saying it's ceremonial deism, Justice Brennan said, while I remain uncertain about these issues, perhaps it can be considered as a form of ceremonial deism. And he came up with the reasons why he said, okay, maybe this is it. If this were ceremonial deism, do you think we would have gotten the reaction that we got? This isn't ceremonial deism. People want God in government because people always want their religion reflected in government. And the things that Wendy Kaminer is afraid of occurs. The reason we got to a stage that says we can take money and fund all these religious groups is because we started out saying, hey, well, first thing we said, we can put God in our government. We can put God in our Pledge of Allegiance. We have God as our national motto. We, the United States of America, George Bush says we hold ourselves out as the beacon of religious liberty. And of all the mottos we could have come up with, we say, in God we trust. I mean, isn't that bizarre? Couldn't we say, like, in religious freedom we trust? Or in a million other things we trust? In honesty we trust? In fairness? In equality we trust? As James Madison 14 times spoke of. So it seems to me pretty clear what they had in mind, and this stuff is real stuff. We should treat people, give equal respect to all religious views, and you won't have to worry about getting to the problems that she's talking about if we adhere to that strictly. This is not a trivial issue. It's a huge issue, as evidenced by the fact that the Congress of the United States stopped what they were doing. I don't think they've ever done that before, except after 9/11. Never in response to a court decision. They stopped what they were doing to pledge allegiance under God and let everybody know that we Americans really believe in God. Those atheists, well, they're guests in our country. But we know the real Americans believe this. And if you can do it to atheists, you can do it to Catholics, you can do it to Jews, you can do it to women, you can do it to blacks, you can do it to anyone. And you can't do it under our Constitution.
Right rebuttal, then we'll open it up to you. I know what a right is.
I am always very wary of hyperbole. And I think suggesting that the presence of under God in the pledge at a time when, in a country when nobody is obliged to say the pledge, nobody is obliged to say under God, I think to compare that to being forced to sit on the back of the bus, or not to have a place at the lunch counter, or not to be able to go to the same schools that other people go to, I think that's the kind of hyperbole that we should watch out for. It reminds me of what I critiqued in the personal development movement when I would hear people talk about child abuse as including everything from being occasionally yelled at for not doing your homework to being raped. Now, I understand, of course, that there are some non-theists, atheists, agnostics who react much more strongly than I do to seeing God on a dollar bill. My husband, who's sitting here, happens to be one of them. So I understand that. I know that to some extent we are making subjective judgments here about what we should challenge and what we should leave alone for political reasons. I would, for example, challenge posting the 10 Commandments in a classroom. I don't like having the 10 Commandments in a courthouse. Some people think that's trivial. I actually don't think that's trivial. I think that's sectarianism. I mean, I could give you 15 minutes of arguments why that's important and why that's worth fighting. But I think it is also extraordinarily naive politically for Michael Newdow to suggest that, if we didn't have under God in the pledge, if we could take God off the dollar bills, then somehow we wouldn't have government-funded religion. That one of the reasons that atheists are so maligned, and of course atheists are very maligned in this country, and he suggests that one of the reasons for that is because we have under God in the pledge and God on dollar bills, and because we tolerate that. Well, the first thing I'll say is that correlation is not causation. And I really doubt very much in this case that because we have God on a dollar bill that atheists are maligned. I could probably give you another 15 minutes in my own theories on why atheists are so maligned. I think you'd be hard-pressed to find any period in human history where when a great many people were not religious. I think people seem, for whatever reasons, I'm not an evolutionary biologist, nor am I a theologian, but for whatever reasons, the great majority of people seem inclined to believe in God. People are very, very tribal, and I don't think you can separate the problem of religion, what I see as the problem of religion, from the problem of tribalism. I think the reasons why atheists are maligned are a lot more complicated than the fact that we have under God in the pledge and God referenced on a dollar bill.
And Phil, do you want to last word?
Sure. Let me just try to focus on the main point. And I think the crux of the matter, Mr. Newdow's understanding of what it means to be treated equally or with equal respect is problematic. Implicit in his comments are a psychological understanding of equality. That is, the right to be treated equal means the right to feel comfortable or feel accepted in a classroom. No child is punished for not saying under God. Nothing happens to anyone who doesn't say under God. His argument is that one shouldn't have to feel pressure. That is, one has a right to feel comfortable. That's what it means to be treated with equal respect. He has a lawsuit trying to get In God We Trust off the currency. Why? Because he doesn't like using currency with religious language on it. Is he punished? Is his money not accepted because he's an atheist? No. Right? It's a psychological understanding of equality. Look, I want everyone to feel as good as the next person, but you don't have a right to feel comfortable. You don't have a right to be liked. You don't have a right to be elected to office unless you can get people to vote for you. And so whether or not atheists are treated as well as anyone else in elections depends on, you convince them you will serve them well. No one prohibits you from running for office. Right? That would be an abridgment of religious freedom. If he couldn't run for office because he was an atheist, if he couldn't attend a public school because he was an atheist, if his daughter was kicked out of school for refusing to say under God, I'd be the first to be on his side. But none of that's happening. And that's why I say he misunderstands the right. He misunderstands what it means to be treated equally under the law. Let me also, since I teach the American founding, your history is bad. And I'll just, one example. You cite the Virginia Statute for Religious Freedom as sort of the crux, as the document to support your side. But how does the Virginia Statute for Religious Freedom begin? What's the first line? Almighty God has created the mind free. Under your understanding, the Virginia Statute for Religious Freedom would be unconstitutional. And I think that suggests that shows how you've misunderstood both the history of the drafting of the First Amendment, its meaning, and what it means to have an equal right to religious freedom.
I think we've had a very, very respectful but sharp interchange, and now it's your turn to participate. So let's hear from people. Go ahead. Can you stand?
Yeah. Your argument seems to be kind of predicated on the idea that secularism is as valuable a form of belief, like it's a religion just like any other religion. But how do you keep? I don't mean to say religion. That's a mistake. It's a belief that's as valid as any other set of beliefs. How do you keep? I mean, I suspect that you subscribe to separationist idea of the separation of church or of the First Amendment, and I wonder how you keep accommodationist points of view from appropriating that idea and saying that because secularism is as valuable a belief as a different style of belief, that like religious symbols should be allowed in the public square, or like, nativity scenes, something along those lines.
Well, again, you're confusing the public square with the government, okay?
They're two separate things. Nobody is stopping. You want to put a nativity scene on your front lawn, or your church's front lawn, or any property that you own, or public property, if it's your nativity scene and the public allows you the right to put scenes on public property, you have the right to do that. What you don't have the right to do is to get the government to do it. Okay? It's a very simple distinction. I'm not sure why that keeps getting becoming.
Just another example, the Supreme Court case in Virginia about allowing funding for the University of Virginia to allow a religious-based...
The Rosenberger case.
Yeah.
Yeah.
What about a situation like that?
I think Rosenberger actually is fine. Okay, I think that what we have there is we have government, all right, funding groups equally, and what the people who were arguing in Rosenberger were saying was essentially hostility to religion. Because this is religion, you can't have it. Okay, I'm not for hostility to religion. Right, what I'm having is everybody treated equally. Right, I'm not asking for one nation that denies God exists. I'm asking one nation indivisible, as it was for 62 years. And the question is, why do all these people want to have this God stuff in their pledge? Right? What is so important that you would? Why would you trample on that idea of equality? It certainly is not treating people's religious views equal to say that we are a nation under God when we know that there are some people who disagree with that. Anymore, could we have one nation under Jesus? Would that be okay? Why is that one? Maybe Phil can answer that. Why is that one no good? Right? Because everybody was just as much Jesus believers as they were God believers back then. It was almost entirely Christianity that we had. Would everyone say, okay, well, one nation under Jesus is okay? I mean, you don't have to say one nation under Jesus. You could leave that out. What were your other arguments? It's not a question of that. Whether you have to say it, that's a free exercise question. The question we're talking about is the Establishment Clause here. And take the prototypical, and by the way, it doesn't say they can't establish religion. It says a law respecting an establishment of religion. I don't know how you can phrase it more broadly. They wanted anything that had to do with this, the government to stay out of that issue. Right? Take the prototypical Establishment Clause violation. The Congress of the United States, we hereby declare, and choose your religion, the Episcopal Church to be the official established religion of the United States of America. Would that be okay under the Establishment Clause? Does anyone think that would be okay? Because all of Phil's arguments would apply there as well. Yeah, you don't have to fund the Episcopal Church. You don't have to say you're an Episcopalian. You don't have to do anything with it. We just want to establish that as the national church. Well, that's what you're not allowed to do. And we'll go back to what James Madison said. It degrades from the equal rank of citizens. Wendy, you can tell us, how is that different? I know you don't like the analogy, but tell me how that's different between water fountains for blacks and whites. You both get to drink water. As a matter of fact, now there's 2 water fountains. You don't have to wait as long.
I want to say a word about what some regard as hostility towards religion. I want to say a word in favor of it. I'm a little surprised to hear Michael say that he thought the Rosenberger case was decided properly, because I think it was a terrible decision. That case involved using student fees, essentially, to fund what was an evangelical magazine. A magazine that was very actively and explicitly engaged in sectarian religious proselytizing. To suggest that not using what in that case were the equivalent of tax dollars, if this were a small government, these would have been tax dollars, to suggest that not using tax dollars to fund sectarian religious proselytizing was a form of viewpoint discrimination is, for one thing, I think that really is establishing religion, but for another, there's a way in which that reduces religion to the level of all the other isms. You fund the feminist magazine, and you fund the Marxist magazine, and you fund the secular humanist magazine, which is not a religious magazine, so you ought to fund the evangelical Christian magazine, and it seems to me that a lot of the religious people who are arguing for more government support of religious activities want to have it both ways, and I think that's partly a very important point that Michael is making that a lot of people often miss, that there is a big difference between having an open public square in which religious people and non-religious people have equal freedom to say whatever it is they want to say, and having government pay for one group's speech and not another group's speech. There's a big difference between the exercise of religious right and the exercise of religious power. You often hear advocates of school prayer say that not having an official school prayer is a denial of the right of religious students to pray. And I think that's exactly wrong. I think what it denies religious students is the right to have the school impose their prayer on other students. Now, that's essentially the argument that Michael Newdow is making in the pledge case, and I think, I think in principle it's not really a bad argument, because I disagree with Professor Munoz's saying. This is, the government is, it was the government that inserted under God in the pledge. It's the government that wrote the pledge. It's not as if a group of students just spontaneously decided to get up and say the pledge and include an under God in it. That's not what we're talking about here. We're talking about an exercise of religious power. I mean, we could probably go back and forth for the next 2 hours deciding whether we think this is an important exercise or a trivial exercise, and I don't think that's going to get us anywhere. I think we both stated what we think about that, so I'm not going to go on about it. But I think it's very important to keep in mind the difference between exercising a religious right and asking the government to help you exercise what is essentially a religious power.
Can I ask you to respond to the analogy with separate water fountains?
Well, we've already been over that.
I think we've done that.
I think
I didn't
we
hear.
could get some more questions.
Okay.
Yeah. I'd like to make 3 points, if I can get I don't think you resolved the difficulty you said in respect to the Declaration of Independence and the Preamble. It's the Preamble to the Constitution. And it talks about the rights established by endowed with the Creator. And that's really giving a rationale for the origin of a right. And that's a good, not only a theoretical point, but it could well be understood as a universal point. I just don't see how you can say, well, here's the Constitution over here, we can forget all this. In the Declaration, which seems to me to give a green light for an open-minded attitude. When you understand the Constitution, the Declaration can serve as a guideline. When you say in the Constitution, with respect to the oath, it doesn't say, so help me God. I think that is very wise what they did, and that's consistent with what I hold, because the option is there for you to have each person who gets up there. They can say, so help me God, if you want. At the time of the administration of the oath, whoever's administering the oath can say, you find it offensive to say, so help me God. No, I want it, okay? And then it says, so help me God, and that individual subscribes to it. You come up, and they ask you, do you find it offensive? Yes, I do. So we don't say, so help me God with you. So I don't see a real problem there. I see it as a kind of adaptation, and it's consistent with the preamble to the Constitution. I think historically, you need a historical basis to help understand the Constitution, and is here a problem. And what I mean by that is, if you look at the historical religions and you look at the relationship to philosophy, which is a secular discipline, you had Plato and Aristotle who rationalized the existence of a God. And they didn't accept the mythology. They thought the mythology, which you can call it the revealed religion of the Greeks. They didn't accept it. They said it's very helpful. But there's still a natural truth in respect to the existence of God. I mean, you have major thinkers who are classified by us as pagans, holy men. There's nothing to do with Christianity or Revelation or with Judaism. So in the discipline of philosophy,
Can you bring your point somewhere? Could we?
Well, I think it's not a religious test to say under God. It's a natural truth, all right? And you can have a nation that accept that as a natural truth, all right? And I don't see any anything inconsistent in having that as part of an understanding of the Constitution. As a matter of fact, I think it should be enforced, not enforced, but I mean, it should be made explicit. Such that for the majority, and those that oppose it, well, they don't need to participate in it.
Thank you. I know Phillip Muñoz has thought a lot about the relationship between the Declaration and the Constitution.
Sure, yeah, I think, Michael, I think you make a mistake in so quickly brushing off the Declaration. This is not my line, this is Abraham Lincoln's line.
I knew you
the
were-
Constitution, I learned this here at Boston College. The Constitution is the means to protect the ends set forth in the Declaration. As Lincoln said, the Constitution is the frame of silver that surrounds the apple of gold, which is the Declaration. So the Declaration has 4 references to God in one way or another. We're endowed by our Creator. They appeal to the supreme judge of the world for the rectitude of their intentions. They invoke divine providence. All that, a public reading of the Declaration of Independence, or asking the students to recite the Declaration of Independence in a public school, if Michael pushes his argument, would be unconstitutional in his understanding, for the same reasons under God would. Well, to suggest that the Declaration is unconstitutional is a complete misunderstanding of the whole purpose of the Constitution, which is to protect the rights articulated in the Declaration itself.
And if I could just add a word to that, because I knew that, I'm pretty sure that Phillip Muñoz would mention Lincoln in this context. And my understanding is that when Lincoln sought grounds for the evils of slavery and the eventual abolition of slavery, he couldn't find it in the Constitution, which at the time did not include the 14th, 15th, 13th, 14th, 15th Amendment. That he had to find it in the Declaration, and that it was the language of the Declaration that made it possible for almost all of Lincoln's rhetoric about slavery to take hold. So, you know, in that sense, I wouldn't want to separate the Declaration of Independence from the Constitution either, the way you suggested, because I think if we did so, we'd lose the very language of equality that's so important to you.
I just don't think it's equal to say all men are created equal and then simultaneously say they are endowed by their Creator. You're not giving equal respect to I don't believe that a Creator that existed that gave us our equality.
But
And you just saw a perfect
without that appeal
example.
to all men are equal.
But you don't
we
need
still have slavery.
God. No, he could have said it. But the equality doesn't need God to have equality. You just saw a perfect example. It's the truth that God is the one who gave us here. It's the truth. It's the truth. No, it's not the truth. The truth is, under our Constitution, that we're going to respect all religious views. The ones that say there is a God and the ones that say there isn't a God.
But Michael, you're so slippery because you say we're going to respect all people are created equal. What does it mean to respect in your view? What does it mean to be treated equal? It means that people won't advance arguments that invoke God. That's what it means to be respected.
No, it means the government won't. It means the
Okay,
government.
fair enough.
You're not being fair to me.
Fair
It
enough.
means
That's
the
fair. That's
government
fair
won't.
enough.
Thank you.
Or the people acting through the Declaration of Independence won't.
No, the government. It was Congress that put under God in the pledge. He's talking about
Wasn't
government action.
Okay, but the Declaration of Independence is a statement on behalf of the people, right?
In 1776,
Yeah, but
13 years before we came up with a constitution that said we're not going to have God in our government. They could have done what all the other states do.
That's
Why
my
isn't
very
it
point,
there?
that you would make the Declaration itself
And the Virginia Bill for Religious Freedom didn't get passed in 1779 and did get passed in 1786. There was a change in thought. All right? And the Declaration of Independence said we're going to institute new government laying its foundation on such principles. They could have laid it on the foundation on the principle that there's a God. They chose not to. And you want to say, well, you know, I can't find it in the Constitution, so, well, there it is in the Declaration, I'll use that one. That doesn't go along with this idea.
Can I just suggest that I don't really care what the founders would have said about this debate?
Okay?
And
We know that.
do you really know that? I mean, I have enormous respect for the Constitution and the Declaration, and I think they have served us very well, but I am not a fundamentalist. I also look at the way the court has interpreted over the years. I think about what it means to us. And, you know, even if Thomas Jefferson and I might agree or disagree on some things, James Madison and I might agree or disagree on some things, but that's not going to determine what I think, and I don't think it should determine what we think.
There's a question.
Well, to me, it seems like what I'm hearing is that the main issue is that, you know, Title 10, Section 4, Clause 2 of the U.S. Code says the Pledge of Allegiance to the United States will be, you know, and so-and-so under God. It's not necessarily whether kids are forced to say the Pledge of Allegiance in school or forced to say under God in school. It seems like and correct me if I'm wrong, what you're saying is that Congress enacted a law which enshrined under God in the U.S. Code.
Essentially said God exists.
So, I mean, when we talk about the Declaration of Independence and how it was formative of the 13th, 14th, and 15th Amendments, the fact that there are 13th, 14th, and 15th Amendments says that those things were seen to be It's that, I mean, the constitutional process enacted those into law, into U.S. law. I mean, they didn't say, okay, well, the Declaration says it, that's good enough. They said we have to enact these amendments to enshrine those in our law. So it seems like when the legislature says something, I think Michael's point is valid, that it is actually saying something. It is in the U.S. code that under God is in there. I mean, it's...
Yes, the premise of your argument is that the Constitution does not allow the government actors to invoke God or endorse, to use a more constitutional term, endorse religion. And that is what Justice O'Connor said. That's wrong, is what I'm saying. So I deny the premise of your argument.
So you think government should be able to say we're one nation under Jesus?
I don't think the government should do it.
If the majority wants one nation under Jesus, is that okay?
The question of whether it would be unconstitutional or not is a difference between...
So you think it would be
Would it be
constitutional?
unconstitutional for them to say one nation under Jesus?
I don't think it would be unconstitutional. I would not support it.
And the difference,
and why
the difference
wouldn't?
is what?
But wait. Not everything that's bad is unconstitutional.
Agreed.
Why did you just said you think it would be unconstitutional? Why do you think
No,
under
I
Jesus?
didn't think it would. I said
Oh, you
no. I
said
did not think it would be
I'm sorry.
unconstitutional.
Oh, okay.
Right, but I mean, the multiplicity of sects, the good sense of the American people, have to be depended upon too. The Supreme Court is not some platonic overseer that prevents every bad thing from happening. The question of is it constitutional or not is a different question from is it wise or not.
I agree, but I would say that if government has no power to endorse a religious view, and I think that's a correct assessment, it's clearly endorsing a religious view.
Let me give you.
How about one nation under the Episcopalian Church? Would that be okay with you?
Yeah, but is there a distinction between
Eric,
natural religion?
maybe we have another question over here.
Well, this is a kind of a follow-up to encourage you to say a bit more about what you were just saying. I find it interesting in this case that there's so much dissembling among religious people about support for the pledge, especially in the courts, about why religious people might want to keep the pledge, and those who profess that the words under God affirm our nation's belief in God and that we affirm our belief in God when we say it, go into court and say, well, it's ceremonial, it's not really meaningful as a religious expression. And they admit as much, and I'm sure you're familiar as I am with the people who do that. And it's a tactic. What built upon your initial comments was that you seem to agree that that's an odd arrangement, that the First Amendment jurisprudence has brought us to this point where religious people must assemble in front of the courts in order to defend their religious views. And I wonder if you'd say a bit about that, and then how would you open the doors? I mean, would you sweep away all the tests that have been out there? What's the next step after?
Sure, that's a fair question. Let me try to explain your first point a little bit more so everyone understands, and then address the second. The reason why there's disassembling is because of Justice O'Connor. She controlled Establishment Clause jurisprudence for almost 20 years. And her test was the endorsement test. If government action, if a state action is perceived to endorse religion, it's unconstitutional. Everyone knew she had the fifth vote. And therefore, if you wanted to defend a religious action, or if you wanted to defend those who would defend traditional religious expressions in the public square, had to say it's not really religious, because if it was religious, it could be perceived as an endorsement of religion.
You saw that very clearly in the Ten Commandments cases last year.
Yeah, and that's, to me, that just indicates the problematic nature of O'Connor's test. Right? And that's why I say from the beginning, Michael Newdow should have won his case. Right? O'Connor backpedaled in her opinion. I mean, O'Connor's opinion is a joke of jurisprudence. I don't know how she could take herself seriously writing what she wrote. You know, it makes no sense whatsoever. He had the right legal argument. He should have won based on the precedents. The problem is the precedents themselves. So to get to your second question, well then what should the Establishment Clause say, or how should we protect religious freedom? I too share Wendy's concerns of religious favoritism, and the position I have set forth, which I think is fair to both sides, is the idea of no privileges on account of religion, no punishment on account of religion. But we have to take seriously, what does it mean to receive a privilege? What does it mean to be punished? right? It doesn't mean psychological feelings of exclusion. Let me just cite James Madison. A sanction is essential to the idea of law as coercion is that to government. That's from the Vices of the Political System in the United States, written in 1787. A punishment is when you are thrown in prison, fined, denied an otherwise available benefit. Right? And a privilege is the opposite. You get something other people don't get. You get something material. You're eligible for an office in a way someone else is not. Not that you feel better. Right? And that, I think, it would be a fair way to adjudicate. I mean, what we want is we don't want people to be punished on their account of religion, and we don't want religious groups to be able to use the apparatus of the state to benefit themselves and to harm others. I think that's what everyone wants. And I think that approach, which I think is most consistent with the founders, who I do care about, would be the best approach.
When you outed me, you can assume that because I object to under God and the money that I'm an atheist, and that's true. And when she said we were married, you can assume I'm not heterosexual, and that's true. So you know
Not
something.
necessarily.
And you can assume
We know a lot of married gay people.
she outed me again. So now you know perspective from which I'm coming. I suspect that the perspective from which Professor Munoz is coming is one that Michael's use of the word under Jesus or under the Episcopal Church might have felt a little different to him. But if Michael had used the example of under Allah, I wonder whether the government establishing that phrase in the pledge to the flag, which represents the liberty for which we stand, would have been something that Professor Munoz would have defended. Because
How did I defend it? You're misconstruing exactly what I said.
You said it was constitutional.
Granted. However, I have to agree, although I don't like to do so, I rarely do so, but agree with Wendy that it almost doesn't matter to me the constitutionality of it. It's the justification of the government establishing a religion or a phrase about a religion. I also disagree with Wendy about